Okay. So we are starting with Unit 2 of your Lesson 16. Unit 2 deals with the Contract Labor Regulation and Abolition Act 1970. So before we get into that, we have to understand what is contract labor, right? So history of legislation is the first topic given to you. Contract labor has its roots from time immemorial, but the size of contract labor in India has significantly expanded in the post-independence period because we had an expansion of construction activity following substantial investment in the plants. During early period of industrialization, the industrial establishments were always faced with problems of labor recruitment, low status of factory workers, their lack of mobility, their caste and religious taboo, language issues. These were all problems faced by the employees as well as the employers. That is, at the time, it was British employers and their representatives because they were not particularly familiar with these issues. They were not able to employ labor easily. So they had to get the help of middlemen. They had to depend on middlemen who helped them in recruitment and control of the labor. Okay, so these middlemen are called as contractors and they are called by different names in various parts of the country. Okay, so contract laborers were considered as the exploited section of working class mainly due to the lack of organization on their part. Due to this, Whitley Commission in 1860 recommended the total abolition of contract labor by implication. But total abolition of contract labor was not possible. Okay, so following this, the government constituted various committees to study the socio-economic conditions of contract laborers. You can see the various committees. Bombay Textile Labor Inquiry Committee, Bihar Labor Inquiry Committee, the Rega Committee. As a result of the recommendations of these committees, the scope of definition of workers in the Factories Act, Mines Act, and Plantation Labours Act was enlarged to include contract labor. So, contract labor oda socio-economic conditions பத்தி research was done by appointing various committees. After hearing to the recommendations made by these committees, workers அப்படின்ற definitionல contract laborers-யும் different actsல government include பண்ணுச்சு. What are the different acts? Factories Act, Mine Act, and Plantation Labor Act. So contract laborனா யாரு? Basically, these are group of people who are employed by a contractor, by a middleman, and the middleman will be touched with the principal employer. For example, ஒரு building construction contract இருக்கு அப்படின்னா building construct பண்ற அந்த person or அவரோட representative will talk only to the contractor. He'll not directly talk to the laborers. Contractor வந்து will talk with the laborers. So what will be the terms and conditions set by the principal employer? அதாவது அந்த building owner will be known only to the contractor. Contractor என்ன சொல்றாரோ அது மட்டும் தான் இந்த contract laborersக்கு தெரியும். Yes or no? And mostly these
Yes,
people
ma'am.
will be illiterate. They'll be very poor. They'll be coming from very poor backgrounds and they'll also have language barrier. Usually they'll be migrant workers, so they will not understand the language of the local area. So they'll be easily exploited by both the contractor and the principal employer. Okay, so to protect their rights, we need to have a particular registration, and that is the legislation that we are going to talk about in this particular unit. Understood? The need for Contract Labor Act. So how Contract Labor Act came into place? It was in the second five-year plan. The Planning Commission stressed the need for improvement in the working conditions of the contract labor, and thus they recommended a special treatment to the contract labor so as to ensure that they have continuous employment where it was not possible to abolish such type of labor. So total contract labor abolish பண்றது கஷ்டம். So abolish பண்ண முடியல அப்படின்னா then you have to help them to get at least get continuous employment so that they can continue to live their lives. So it was discussed at various meetings of tripartite committees at which the state governments were also represented. And general consensus of the opinion was that the system of contract labor should be abolished wherever possible and practicable. So எங்கெல்லாம் முடியுமோ அந்தந்த செக்டார்ஸ்ல அந்தந்த ஆர்கனைசேஷன்ஸ்ல you have to abolish contract labor. But in case the system could not be abolished altogether, then at least the least thing you could do is develop the system in such a manner that the working conditions of contract labor will also be regulated, and you can ensure payment of wages and provision of other essential amenities to the contract laborers also. So what is the purpose of the act? Wherever possible, this contract labor system itself should be abolished. But if the system cannot be abolished in certain cases, then in those areas, you have to give them proper working conditions, ensure payment of proper wages, and also provide basic amenities required to them. Clear? This is the objective. Based on these views, the Contract Labour Regulation and Abolition Act was passed in both houses of parliament. It received the nod from the president on September 5, 1970. It came into force on 10th February 1971. Okay, based on your act, Contract Labor Prohibition Act, Central Rules 1971 are also notified by the central government when the act was enforced. What is the object and scope of the act? The preamble of the act, as I told you, preamble is an introduction to the act. So preamble of that tells you about what the act is all about. The preamble of this particular act states that the purpose of this act is to regulate the employment of contract labor in certain establishments and to provide for the abolition in certain circumstances and for matters connected therewith. So wherever possible, you will abolish or you will ban contract labor. If that is not possible, you will at least try to regulate how contract labor is employed. You have a case here in Gammon India Limited versus Union of India. Following was the observation made by the Supreme Court. Supreme Court observed that the act was passed to prevent exploitation of contract labor and also to introduce better conditions of work. The act provides for regulation. At the same time, the underlying or the basic principle of this act is to abolish contract labor wherever possible. But when it cannot be abolished, the policy of the act is that the working conditions of contract labor should be regulated as to ensure payment of wages and provision of essential amenities. Right? This is the major objective, and it was upheld by Supreme Court also when it gave this judgment. So based on your act, contract labor regulation central rules were also passed in 1971. According to Section 1, the Act extends to the whole of India, and it applies to whom? It applies to two type of people, especially to every establishment which is employing contract labor. Okay, every establishment which is using contract labor in which 20 or more workmen are employed on any day, and if they were employed previously, so past 12 months, like if you are using, if you were using contract labor, then this act will be applicable to you. Similarly, if you are a contractor where your job is to provide contract labor, then the act will be applicable to you. Clear? And the appropriate government may, after giving not less than 2 months' notice of its intention, by notification the official gazette, may apply the provisions of this act to any establishment or any contractor, even when the number of workmen is less than 20. So the act tells you 20 or more people employ Pandingana, act will be applicable, but at any point of time, government may even bring in establishments or contractors who have less than 20 people involved. Clear? Where the disputes relate to service conditions of workmen engaged in the factory canteen maintained by the company, there is no question of abolition of contract labor, so the dispute will now be referred to Industrial Tribunal for adjudication. So first thing you'll see is whether you can abolish contract labor. When contract labor cannot be abolished, then the dispute is now transferred or referred to the Industrial Tribunal for adjudication. That is, they look into the needs of the labor workers there and try to ameliorate the standard of living. According to Section 1, subsection 5, the Act is not applicable to establishments in which work only of an intermittent or casual nature is performed. So, intermittent is the work is not continuous. As and when the demand is there, as and when need is there, the work is done. That is called as intermittent work. Okay, if you are an intermittent or casual work type of organization, then this Act will not apply. Okay, how to determine whether the work is intermittent nature or not? For the purpose of the subsection, Work performed in an establishment shall not be deemed to be of intermittent nature. Number one, if it was performed for more than 120 days in the preceding 12 months. Over the year, 120 days for work நீங்க பண்ணீங்கன்னா, then it is not of intermittent nature. Next is, if the work is of seasonal nature and it is performed 60 days in a year, then also it is not of an intermittent nature. Okay. Like you saw in your Child Labor Prevention Act, here also you have definitions which are important for understanding your act. So that definitions are usually given in section 2 of any act. Here also it is section 2. According to section 2, we have the following definitions. Appropriate government. Again, if it is an establishment which is under the Industrial Disputes Act, then you refer to central government. Any other establishment other than central government, you will refer to the state government. Following that, you have the definition of the word contract labor. A workman shall be deemed to be employed as a contract labor or in connection with the work of an establishment when he is hired or in connection with such work by or through a contractor with or without the knowledge of the principal employer. So, ஒரு laborer, contract laborer ன்னு எப்ப சொல்வீங்க? When he is employed by a contractor. ஒரு மிடில்மேனோட இன்வால்மெண்டோட ஒரு ஜாப்ல அவர் எம்ப்ளாய் ஆயிருக்காரு அப்படின்னா then such a workman is called as a contract labor. Okay. How can you distinguish a contract labor from normal employees? They can be distinguished from employees in terms of their employment relationship with the principal establishment and the method of wage payment. A workman is deemed to be a contract labor when he or she is hired in connection with the work or contract for service of an establishment by or through a contractor. And they are indirect employees, that is, contract labor வந்து எந்த பேரோல்லையும் இருக்க மாட்டாங்க, attendance ரோல்ல இருக்க மாட்டாங்க. Wages will not be directly paid by the employer. Wages will be paid to the contractor, who will then in turn give the money to the laborers. Clear? This is how you can differentiate between normal laborers and a contract laborer. Who is a contractor? A contractor in relation to an establishment means a person who undertakes to produce a given result for the establishment other than mere supply of goods or articles to manufacture through contract labor. So apart from giving goods services, he is also providing labor. It is a contractor who supplies contract labor for any work of the establishment and includes a subcontractor also. When you talk about contractor, you can take the definitions given in various cases. Contractor engaged covers construction of building. A contractor is one who supplies contract labor to an establishment undertaking to produce a given result for it. Subcontractors or piece wages are also called as contractors. So these definitions are based on various case laws and the judgments of those case laws. Following, you have the term controlled industry. Controlled industry means any industry the control of which is under the union has been declared by any central act. So central act control பண்ற ஏதாவது industry இருக்குன்னா it is a controlled industry. Then you have the word establishment. Establishment means any office or department of the government or local authority or any place where any industry, trade, business, manufacture or occupation is being carried on. So any place where contract labor can be employed for any type of work is called as an establishment. So establishment word you can also include a ship or a vessel in which repair work is being carried on. Establishment need not be a place on land. It may even include a ship or a vessel. Something funny?
No, ma'am. No, ma'am.
Next is principal employer. Principal employer means in relation to any office or department of the government or local authority, the head of that office or department. Okay, and if it is a factory, then the owner or the manager, occupier of the factory. Again, in a mine, the owner or agent of the mine, who is the lead there. And in any other establishment, any person who is responsible for the supervision and control of the establishment. So, for whose benefit a contractor is employing a group of contract laborers called as a principal employer. There are three parties involved in this transaction. Okay, there is a principal employer. He needs some laborers to do the work. So instead of directly employing laborers, he is going to go to a middleman called as a contractor. Contractor will then bring in the required number of workers. Okay, the person for whom the workers are actually employed is called as the principal employer. Understood? Next thing you have the word occupier again. Occupier of a factory under Section 2, Clause 10 of the Factories Act 1948 means the person who has ultimate control over the affairs of the factory, where said affairs are entrusted to a managing agent, then such agent shall be called as the occupier of the factory. The person who's taking all the decisions, who's supervising a particular establishment is called as the occupier, under whose supervision the workers will work. Then you have the word wages. Wages shall have the meaning assigned to it in clause 6 of section 2 of the Payment of Wages Act 1936. So Payment of Wages Act like wages oda meaning ennavo, same meaning will apply here. Then you have the word workman. Workman means any person employed in or in connection with work of any establishment to do skilled, semi-skilled or unskilled manual, supervisory, technical or clerical work for hire or reward. Okay. And the following people will not be considered to be workmen. Who are they? A person who is employed mainly in managerial or administrative capacity, a person who is employed in a supervisory capacity. He draws wages exceeding 500 rupees, and his functions are mainly of a managerial nature. And if it is a worker who to whom the principal layer gives out any work to be made up, cleaned, washed, altered, ornamented, etc., then it is not a workman. Following, you have something called as advisory boards. So, as I told you, in all the codes, there is a provision for setting up a central advisory board and a state advisory board. Okay, so central advisory board is set up under the provisions of section 3. The central government shall constitute a board to be called Central Advisory Contract Labor Board. Hereinafter, you will call it simply as a central board. So, what is the function? The function of the central board is to advise central government on all matters relating to contract labor and other functions. What is the composition? Who will be the members? There will be a chairman, and that chairman will be appointed by the central government. There will be the chief labor commissioner, central chief labor commissioner. Ex officio means by virtue of his office. Because he's a chief labor commissioner, he will be automatically part of the central board. Understood the meaning of the word ex officio?
Can you repeat again, ma'am?
When you say somebody is ex officio, it means they are in that position because of the virtue of their office. So in the central board, chief labor commissioner irukanga அப்படின்னா, it is automatically because of the fact that they are the chief labor commissioner. Because they are a chief labor commissioner, automatically they form part of the central board. That is called as the meaning of the word ex officio.
Yes.
Okay. And such number of members, it should not exceed 17, but not less than 7. So there must be minimum 11 members involved and maximum 17 members. Okay. And they are nominated by the central government to represent government, railway, coal industry, mine industry, contractors, workmen of any other interest, which in the opinion of the central government ought to be represented on the central board. So central board, எந்தெந்த ஏரியாஸ்ல இருந்து ரெப்ரசன்டேஷன் வேணும்னு நினைக்கிறாங்களோ அங்க இருந்து ரெப்ரசன்டேஷன் வரும், whether it is employers or workmen or contractors and people who will represent government, railway, coal industry, mining industry, etc. But this number should be minimum 11 and it should not exceed 17. It should be maximum 17. So this will be the composition of the central board. Clear? Provided if you're bringing in representatives of workmen and bringing in representatives of principal employees and contractors, the number should be equal. If there are two people representing principal employers and contractor, then there should be at least two people representing workmen. Clear? Similarly, there is a provision for setting up a state advisory board also. This section 4 of the Act empowers the state government to constitute a board to be called as a State Advisory Contract Labor Board. Hereinafter, you just call it as the State Board. But the thing is that setting up a central advisory board is mandatory. It is compulsory for central government to have a central advisory board. But It is discretionary, that is, it is optional. If the state government chooses to, wants to, it can constitute a state board under Section 4 of the Act. Clear? Yes. What is the function? The same function. The main function is to advise the state government on matters which is relevant to this particular act, and other functions as it may be assigned to do so. Then comes the composition. Again, you have a chairman, but here instead of central government, the chairman will be appointed by the state government. Similarly, instead of the central labor commissioner, you have a state labor commissioner. Okay, and instead of state labor commissioner, in his absence, you can have any other officer nominated by the state government. And here the number of members maximum is 11, minimum is 9. All of them will be nominated by the state government to represent the state. Clear? Next thing is power to constitute committees. These people, that is the central advisory board or the state advisory board, if they need, they may constitute committees for any purposes they may think fit. It is as per your section 5. Okay, if they are setting up committees, then these committees will meet at such time, place, and observe such rules of procedure as may be prescribed, and they shall be paid fees and allowance for attending meetings as may be prescribed. However, கமிட்டியில இருக்க மெம்பர்ஸ் யாராவது ஆஃபீஸர் ஆஃப் கவர்மெண்டா இருந்தாங்க or they are part of any corporation established by law அப்படின்னா அவங்களுக்கு you will not pay any fees for coming to the meeting. Clear? Okay. Moving on, registration of establishments employing contract labor. So as per this act, if you are a establishment, if you are a shop or if you are a workshop or if you are a factory who are employing contract laborer daily or regularly, then you need to get yourself registered under this act. Compulsory. Only then you'll be able to employ contract laborers. So number one, you'll have to appoint the registering officer. In the registration கொடுக்க போற officers நீங்க appoint பண்ணணும். That is the first point. According to section 6, the appropriate government may by an order notified in the official gazette appoint such persons being gazetted officers of the government as it thinks fit to be the registering officers under this chapter. It also will define the limits of the power of these registering officer. Clear? Next thing is registration of certain establishment. Now you have the people who will give the registration. Now we are going to see the process of how an establishment will be registered. It is given under section 7. Section 7 makes it mandatory for every principal employer of an establishment to which this act applies to make an application to the registering office in the prescribed manner for registration of the establishment. For example, you are a factory owner and in your factory you employ contract labor regularly. So it is compulsory for you to make an application to the registering office to get your factory registered. Okay. The appropriate government may by notification in official gazette fix the time period for making such application. So within which time we have to make the application will be told by the government. It is provided that the registering office may entertain any such application for registration after expiry of the fixed period. For example, let us say within 1 month you have to make an application is the rule. Suppose you have failed to make an application within 1 month. Even after 1 month, your application may be entertained by the registering office if you have provided sufficient cost stating that இந்த ரீசன்னால தான் எங்களால டைம்குள்ள அப்ளை பண்ண முடியல அப்படின்னு நீங்க ஒரு ரீசன் சொல்றீங்க, அந்த ரீசன் சாட்டிஸ்ஃபைங்கா இருந்தது அப்படின்னா then your application may be considered. Clear? If the application for registration is complete in all respects, the registering officer then shall register the establishment and issue to the principal employer of the establishment a certificate of registration containing such particulars as may be prescribed. Okay, so whatever you have submitted in the application is considered to be okay. It is all true. It is checked and it checks out okay abdina. You'll be given a certificate of registration for your establishment. So your factory will be given a certificate of registration. அது கையில வந்ததுக்கு அப்புறம் you will be able to employ contract labor. Clear? So section 7 padi it is mandatory to get a registration. Section 8 talks about revocation of registration in certain cases. Revocation is taking back the registration. So if the registered officer is satisfied either on a reference made to him in his behalf or otherwise, that the registration of an establishment has been obtained by misrepresentation or suppression of any material fact, or for any other reason that he may think that the registration has become useless or ineffective, he may revoke the registration. So நீங்க உங்க ஃபேக்டரிக்கு ஒரு ரெஜிஸ்ட்ரேஷன் வேணும்னு அப்ளை பண்றீங்க. அப்ளிகேஷன்ல யூ ஆர் கிவிங் ஃபால்ஸ் டீடைல்ஸ். தட் இஸ் கால்ட் அஸ் மிஸ்ரெப்ரசன்டேஷன். ஆர் அப்ளிகேஷன்ல நீங்க தர வேண்டிய இம்பார்ட்டன்டான டீடைல்ஸ் நீங்க கொடுக்கல. தட் இஸ் கால்ட் அஸ் சப்ரஷன் ஆஃப் மெட்டீரியல் ஃபேக்ட். இந்த மாதிரி பொய் சொல்லி நீங்க ரெஜிஸ்ட்ரேஷன் வாங்கியிருந்தீங்க அப்படின்னா there is a possibility that the registering officer may take back your registration. That is called as revocation of registration. Okay. If he is going to do so, உங்களோட registration அவர் திருப்பி எடுத்துக்க போறாரு அப்படின்னா then an opportunity of being heard should be given. உங்க point of view கேட்கணும். Okay, after asking the point of view of the establishment, the registering officer will decide what to do so. Whether he is going to take it back or whether he is going to allow the registration to stand. Rule 19 tells you the circumstances in which an application may be rejected. If any application is not complete, கொடுத்திருக்க எல்லா particulars நீங்க fill பண்ணி தரல அப்படின்னா then the registering officer will ask you to amend the application. necessary details fill பண்ணி கொண்டு வாங்க அப்படின்னு சொல்லலாம். அவர் அப்படி fill பண்ணி கொண்டு வாங்க amend பண்ணி கொண்டு வாங்கன்னு சொன்னதுக்கு அப்புறமும் நீங்க amend பண்ணி கொடுக்கல, if you omit to do so or fail to do so, your application can be rejected. Clear? Yes? Yes, okay. Effect of non-registration. According to Section 9, no principal employer of an establishment to which this Act applies shall employ contract labor in the establishment after expiry of period under Section 7. And if you don't get a registration, basically you will not be able to employ contract labor. And உங்க period of establishment கொடுத்திருக்க registration period முடிஞ்சிருச்சு அப்படின்னா then you have to renew it. Renew பண்ற வரைக்கும் you will not be able to employ contract labor. The principal employer should also not employ contract labor in the establishment after the revocation of registration of such establishment under Section 8. So Section 8 படி உங்களோட registration அவங்க take back பண்ணிட்டாங்கன்னா you don't have registration anymore, which means you cannot employ contract labor. Clear? 3 கேஸ். Section 7 படி நீங்க register பண்ணி certificate வாங்கலனா you cannot appoint contract labor. உங்களோட period of registration முடிஞ்சிருச்சு, expire ஆயிடுச்சுன்னா then you cannot get it. Then Section 8 படி உங்க registration revoke ஆயிடுச்சுனாலும் you cannot employ contract labor. Clear? Yes?
Clear, ma'am.
Okay. So we will wind up with this for today. We'll continue in the next class and try to complete your chapter 16. You have one more unit apart from this. This unit deals with contract labor. The first unit deals with Factory Act, which is an important act. Okay. All right.
Okay, ma'am.
Thank you. Have a nice day.
Thank you, ma'am.
Thank you, ma'am.
Thank you, ma'am.